Good morning, everyone. Good morning. Welcome to today's webinar, a webinar which is organized by Maharashtra Judicial Academy in collaboration with SCC Online. This webinar is being organized only, especially for the advocates of Maharashtra State who are dealing with the commercial disputes. And please feel free to extend this invite to your other brother advocates who can join the session. This video would be available on YouTube with the same link that you have joined in. Today's webinar is on fundamentals of civil disputes and commercial disputes, pleadings and the role of documents in commercial disputes, and role of pre-trial procedures, case management hearing, etc., and how evidence decides a matter in commercial disputes. To have this session, we have a senior advocate from Supreme Court of India, Dr. Arun Mohan sir, who will be taking this session. And it will not be just a detailed session or talking about verbally, but sir would also have some pictorial graphs that he has specially made for this session that you can refer to. So those sheets will also be visible on the screen as and when we proceed with this thing. With me, I have the Joint Director, sir, from Maharashtra Judicial Academy, Sudhakar Yellagara, sir, will be will be the co-host for this session. I have Ms. Ma'am Palak Jamadar, ma'am, from Maharashtra Judicial Academy. And my name is Chetan Singh Gill. So we'll all be working together to make this webinar success. I hope you will all like it. Without any further ado, I will pass the baton to Yellagara sir to welcome Arun sir and start the session. Sir, over to you.
Namaskar. On behalf of the Maharashtra Judicial Academy, it's my pleasure to introduce today's guest speaker, Dr. Arun Mohan. Dr. Arun Mohan is a senior advocate, Supreme Court of India, stationed at Delhi. Sir was enrolled as a lawyer in 1970. He was designated as a senior advocate at a very young age in 1982, that is at the age of 33 years in those days. Sir has practiced in a wide field of litigation, including subjects like banking, real estate, property dispute, succession, specific performance, and partition. He continued with a busy practice as a trial lawyer till 1999. Then he shifted focus to a research work titled Justice, Courts and Delays, and devoted most of his time and energy and even resources to it. Targeting at a wide range of audience, the project endeavors to find ways and means to prevent the inefficiencies that have become part of the Indian legal system. Further, the work is based on the premise that the citizens' rights to social goods, services and opportunities to become a reality needs efficient and timely justice delivery, which is also essential for economic growth and social welfare. Dr. Arun Mohan's another research work is Housing for Middle Class. It examines the problems faced by the housing sector across all its stratas and comes up with practical solutions on how cost can be reduced and actual development be carried out. Moved by the plight of road accident victims, Sir has also penned a 728-page book on road safety. Sir is regularly invited to address the judicial academies and to lecture to the students at the law schools. Sir has been visiting the Maharashtra Judicial Academy since 5 years. Sir is really well devoted for the improvement in the judicial system, the justice dispensation system, and it's my pleasure to invite you and welcome you, sir, to the Judicial Academy virtually. Sir, you are welcome to the Academy. On behalf of the participants also, I welcome you, sir. And coming to, before that, it's my pleasure to welcome all of you, the advocates, the office bearers of the Bar Council of Maharashtra and other bar associations, and especially from the districts and taluk offices, and all advocates. We are aware that due to the recent notification, the commercial disputes are now to be dealt with by the courts at the taluka level also. The jurisdiction has been given to the civil judge senior division also, and therefore this subject has assumed importance than it was earlier before conferring the jurisdiction on the civil justice division. Therefore, the Department of Justice, Government of India, has asked the Academy to conduct this kind of trainings not only for the judges but the other stakeholders also, including the advocates and staff members. We have conducted this program for the judges and the staff members, and today we are conducting this program for the advocates. I'm very thankful to all the office bearers of the Bar Council of Maharashtra and Bar Associations for lending their support by sharing all the link for this program. And with this welcome note, now I request Dr. Arun Mohan sir to start the session. So thank you very much.
Good morning, everyone. I would say my friends and colleagues in the state of Maharashtra. I'm here in New Delhi, where I grew up and I have practiced for 50 years. And it's a pleasure today to have this opportunity to speak to my colleagues in Maharashtra. Well, justice delivery is an important, a very important part of our social and economic setting. We as lawyers practice, yes, we earn money also, but our prime object is ensuring justice to all concerned, including our client. Yet, we want justice at an efficient cost in a reasonable time and not let it be delayed till our client comes and tells us, yes sir, I am tired, I can't take it any longer, I will, whatever it is, I will surrender my rights or settle for less or even cough up money to the other who has filed an untenable case against me. It hurts a lawyer to have his client say that, but then lawyer can only console him. Okay, well, this is somehow or the other the general atmosphere, and there's little I can do personally. Friends, that lawyer talking to his client in his office is right when he says there's little I can do personally. But if he, all his colleagues, those who are present at today's webinar and those who are not present but otherwise practice in the state of Maharashtra, whom I also seek to address, I will say indirectly, at this webinar, if they all collectively got together and that said, yes, we must bring efficiency, timeliness in justice delivery, there is no reason why we should not succeed. Friends, that was on a larger plane. But let me now come down to the basics. Today's session will be in two parts. The first part, till about 12 o'clock, I will address on certain basics which are independent of the Commercial Courts Act. The Commercial Courts Act I will address in the second part. Starting with the basics. First, what is a dispute? We all say we have a dispute and therefore we have a claim, it comes to court. That claim can be tenable or it can be not so tenable. It can be true, it may not be true. It depends on whether it is the plaintiff. It is not that all plaintiffs are always true, and it is equally not that all defendants are in the wrong, many are in the right, and many are not. It all depends on what the facts of a particular case are. Where lies the real dispute is the first task before us to identify. But somehow or the other, we have been, as lawyers, and let me put it, even I myself, for very many years, was a victim of tradition. Where we looked at tradition, ये होता रहा है, यही करेंगे, without realizing what are the fundamentals of dispute adjudication and two fundamentals of civil procedure. After some years of practice as a lawyer like you, when I gave up the traditional approach, and I said, well, let me learn the fundamentals. Let me look at what the CPC provides. A totally different picture emerged. Life as a lawyer became much, much easier. And it was easier, not in terms of the work. I still continued to work 14 hours a day, which I continue even today after 50 years in practice. But today, of course, it is mostly research work and writing that I do. And it's a pleasure. And I'm grateful to the Maharashtra Judicial Academy who are giving me this opportunity to address my friends, my colleagues in the state of Maharashtra on this webinar. And by shedding the bind to the traditional, looking at the fundamentals, looking at the first principles, and rereading the basic CPC, the (1908) model gave me some interesting insight. And that insight is, A, what is a dispute? What are the essentials of a dispute adjudication? And what is the process? A dispute, if I may define, is when one party claims something, the other party disputes. They are not able to settle, with the result that party A has to go to court to claim from the court as relief what he thinks is his entitlement. Court carries out this process, the other responds. I'll come to that a little later because there are three essential elements of any dispute. One, what are the facts? Facts come in two categories primarily, as material facts and as evidentiary facts. The latter only go to help adjudicate the existence or the non-existence of the material fact. On the evidence that is adduced, the court carries out the task of fact-finding, which is the first element as a compound element. The second is law. In India, today 98% plus, maybe 99 plus, disputes are covered by a statutory law. There is a statute. It is not as it was prior to 1860, when it was only common law. Now, the statutes of the British era were continued as law under Article 372 of the Constitution. There were amendments, there were new statutes, but whatever there were some old statutes which were also repealed. But what is the statute prevailing holds the field. The Constitution is supreme, and under that, all statutes have to conform to the constitutional requirements and the edicts. Then the statute is there. So the first part is finding out which statute will apply. I call it the selection of the statute. And then once the statute has been reach the particular section or the provision in that statute, and then read that provision. I call reading, analyzing as a separate category and a prior category as compared to the more commonly known interpretation. Let me take an example. Statutes are of two types: substantive law or procedural law. The CPC, the CRPC, and even the Evidence Act, the Limitation Act, these are all procedural statutes because they assist the court and the lawyers, the parties, to decide what is the rights or liabilities as under substantive law. Examples of substantive law are, on the criminal side, the Indian Penal Code. On the civil side, we have quite a few. Of course, on the criminal also we have very many now. But civil side, we have the Contract Act 1872. We have the Sale of Goods Act. We have the Negotiable Instruments Act. We have the Transfer of Property Act. We have so many other statutes which determine what is the substantive law for that field of operation in which the dispute arises. There are well-known statutes. Incidentally, I omitted Arbitration Act is a procedural statute to help decide. It is not a substantive law in the sense that by itself it does not determine the rights or liabilities of the parties. It's a separate procedure. Yet there is in these statutes, and I would say 100 other statutes which govern the rights and liabilities of the parties, which then come before the court, the disputes as claimed, and then there is the defense to it. Okay, well, yes, these are not the facts, their statute doesn't apply, or this statute has to be read in this way or interpreted in this way. So statutory selection, reading, interpretation is essential as the second main component or element. The third is application of law to the facts as established. When I say established in the judicial process, I mean either admitted on the pleadings or, if disputed on the pleadings, proved or otherwise by evidence that is adduced in the process of the suit. I'm using the word process of the suit as distinct from trial. And there is a reason for it. I'll come to evidence shortly. Ultimately, when these facts which are established are matched to the elements of law, the substantive law, which is by and large statutory, if they give one consequence, the court will give one judgment. If they give another consequence, the court will give the other judgment. These are the fundamentals of the judicial process. I'll explain this by some diagrams, which I'll come to a little later. Then, evidence. What exactly is evidence? Evidence is that the existence or non-existence of those facts which create a persuasive force, a persuasion within us to render the existence or non-existence of a material fact in issue as true or not true. That evidence can be oral, it can be documentary, it can be an article, and as now, in the last few years, society has emerged digital, especially whether it is criminal law. Bulk today is digital, whereas 100 years ago, the bulk, I would say all of it was oral in criminal law. Today, oral is left with a very small segment of persuasive force against the resistive force of the presumption of innocence. And civil side, once again, it is documents that matter, and that is what we as lawyers have to advise our clients, get us all the documents. We have to guide them that what would be relevant, what they could find, where they would find, and then our task as a lawyer, select it and place it before them that yes, this is material or relevant to the case, so here it is. These have to be filed. So that is the evidence today. Oral evidence, yes, but in a much lesser value grant by the system as compared to documents and digital. These being the fundamentals, the three, I will straight away come to interpreting a statute. And I would request Chetan ji at this stage to place picture 14 from sheet 2. Picture 14 from sheet 2.
Just give me a moment.
Yes, thank you. Thank you. Now, as you will see in this diagram, once the material facts and documents and records have been established, we as lawyers, our duty is to re-verify the applicable statute. Many times, there are statutes which are lesser used and we miss out, but they affect the right or liabilities of the parties, but they govern and we can't afford to miss out. There are exceptions, there are supplements in operation as statutory laws, but we have to see that all of them are at our desk and table and we can then proceed further with a case, whether for the plaintiff or for the defendant. In commercial, it will be the statutes, as you will slowly see, which are, I'll refer to the second session, which will apply, Contract Act being the more prominent one. Then it happens that behind every statute, we go back 2 steps and we come to first principles, that what does our sense of justice tell us if there is no statute, no case law. That is the first principles thinking, which I referred to a while back, and I again point out in this diagram, that if we make a habit, few seconds, go after finding the statute and re-verifying it, go back on the first principles. It will help us. It has helped me to, though I took to this at a later stage, to get much more out of the statute than the rationale. Why the statute was enacted? What is the problem? What is the objects and reasons? What is it that it sought to give a statutory framework for? Because this rationale, as the second step, allows us a far better approach when it comes to the next stages. And when it comes to next stages, my experience with my colleagues here and also with the colleagues in the other part of the country with whom on the educational or continuing education I have been interacting over the last 20 years is that the plain reading of the statute is most important and is normally not carried out. Why? Because there is a tradition that this is not useful. This is another of those traditions, my dear friends in Maharashtra, you have to learn to break and make it a habit after of plain reading of the statute first, after first principle thinking and the rationale. I'll take a little extra time here. Very often, and I'm doing so because very often I'm asked when I'm in the live lecture, in webinar, I don't have that privilege of having your questions. What plain reading is plain reading. What is there about it? No, there is much more to plain reading than our tradition has taught us. And if you see the second part of this picture diagram, it is breaking down the provision of the rule into its elements and sub-elements. Now, if we, as part of continuing education for us lawyers, give ourselves an approach of bye-bye to tradition, and now we are going to every time break the statute into its elements, statutory provision I'm saying, into its elements, that element 1, element 2, because they all operate in a syllogism. If fact 1 is established, fact 2 is established, this is the result. Sometimes an element may have sub-elements. Another interesting thing here, and you will find it in number of statutes, some provisions are bright line, yes or no. But other provisions in the statute often leave it with an elastic band, say reasonable behavior, or so many types come in where the statute gives a much greater leeway to apply that particular element depending on the fact situation in a particular case. And this part develops as, now this is, I'm putting it, interpretational common law, or I may put it in a slightly different language for simplicity, plain reading of the statute common law. May not be so correct the language I'm using, but I think that would express better. And this plain reading of the statute common law is to be found in a large number of our erudite and other judgments from the high courts and from the Supreme Court. Yet the head notes which report that judgment, and because of the large volume, we lawyers tend to read only the head notes. They don't put a separate head note, plain reading of section so and so into of such and such act and its elements. In the body, yes, there will be reference to the elements. Well, I prefer the word elements, but most of the judgments use the word ingredients. Friends, if you just read that statute 3 to 4 times, Even at now, many of you may have put very many years in practice. You will find that elements show element 1, element 2, 3. We can put a footnote type number. And then you will find some elements are firm. Some are exceptions. Some are with the discretion. Some are without discretion. And some carry sub-elements. And that is the pleasure of reading a statute, plain reading, which is also found in judgments, but not so much in our daily practice, especially in the trial courts. After the plain reading and analysis into elements, the next step is interpretation of the statute. Now, this today is given too much of an importance. There is plenty of case law, and there is the General Clauses Act, but it is only a sequel, a second to the plain reading and analysis which I referred to earlier, though sometimes some judgments silently tend to include the elements into interpretation. Friends, for us as lawyers, if we keep them separate and as separate stages, we are able to achieve greater skills to ourselves and greater efficiency in our working. It is only thereafter we turn to the case law. And then it is application of law to the facts as established, which again carries case law or common law, and then finally after a double check, which is the outcome. I still remember as a young lawyer, I was appearing in a matter and I submitted before the learned High Court judge in Delhi. Sir, here is my case. It's fully covered by this Supreme Court judgment. He says, and I was told, and I'm thankful to the learned judge who told me, that helped me develop better. Says, young man, first the facts. Give me the facts in a nutshell. Second, are you carrying the statute with your hand? I said, my lordship, sorry, I'm not. No. Which is the statute? Bring the statute. At that time, photocopies were not so common. Today, I would tell when I address judges and judicial officers, I say, insist on a photocopy, extra photocopy of the provision from the lawyers. And I would request you as lawyer colleagues, make a photocopy, extra for the judge, extra for the other side, mark out the elements 1, 2, 3, 4, and then hand it over to the judge at the time of arguments, and you will see a completely different feeling in yourself and success for you. So that is how the importance of the statute and the analysis thereof comes in. Now, I would request Chetanji to kindly shift a little left on picture 11. Now, picture 11, that's all. Thank you. Depicts fact, law, and application of law to facts as established. Now, request, move up to picture 12. Above this. Yes. In fact, you can go a little left also, so I'll put 12 and 13 together. Other side, right. 12 and 13 together I'll put. Yes. Diagram 12 or picture 12 is for the civil side, where the material facts, if disputed in the pleadings, are then subject matter of plaintiff's evidence and defendant's evidence, upon which the court carries out fact finding. That is number 1 fact. Second is law, which I referred to earlier, principle of law as culled out from and its elements as culled from the statute or the case law. And third is application of law to the facts as established, which is matching the facts with the elements of the law and lead to one result or the other. Although not subject today, but just only to be complete, picture 13 is with regard to criminal side, where a presumption of innocence the resistive force of the presumption of innocence is available to the accused, and the prosecution has to place evidence by way of evidentiary facts which create a persuasive force which outweighs the presumption of innocence, and the court is convinced that yes, he is guilty of the crime. If the prosecution is unable to do so, then there is acquittal. But once again, the basic principle is of judicial adjudication process, the fact, law, and application of law to the facts as established. I will at this stage come back to evidence, and I'd request Chetanji to shift right to the picture 9 on this very sheet. Keep this in the center, please. Thank you. That's all. Now, ultimate fact is a loose term. In a criminal side, it would be murder. In a civil side, it will be entitlement of money or title to property. But the ultimate fact is only a descriptive loose term. There will be anything between 4 to 10, but I have used a notional number 5, material facts, which are how is the materiality determined? That I have written on the left, that if the materiality of a fact depends on the elements of the statutory provision or the principle of law invoked. When a fact averred by one is disputed by the other, it needs adducing of evidence to enable the court to return a finding of fact, i.e. adjudicate whether the material fact in issue is, as a question of fact, true or not true. This is judicial process. Now on the right side, on this picture, you will see material fact 4 was disputed. If this can be slightly enlarged by Chetanji, material fact 4 only. Yes. Now, material fact 4 attached below this are what we call evidence in common parlance or evidentiary facts in a more technical parlance. These evidentiary facts are by themselves not material because they do not correlate to a element of the substantive law, but they operate to create a persuasive force for decision of the material fact which is in dispute. And this is the evidence which is adduced before a court. Now, I go back 100 years. The evidence was mostly oral. Today, with changes in society, it is mostly documentary. If the documents are there, they operate to prove or disprove. In fact, so much so that today, absence of a document which should have been there is in itself an evidence to prove or disprove. Earlier, we used to call it adverse inference by non-production. Today, that adverse inference with the increase in the proportion of documents has virtually become so well grounded that we can call it evidence in itself. So this being the fundamentals of the judicial process, I will request Chetanji to take us to picture 1 on sheet 1. Yes, this also a little more to the other side, please, so I'll have the others also. Yes, little more. Perfect, perfect. Now, this picture 1 are the 5 stages of the judicial process. Now, it's a slight combination of the 5 stages as have always existed in our CPC. Only we have not paid the deserved attention to stages 1, 2, and 3, or even 4. However, The Commercial Courts Act, the subject of today's webinar, gives as a guideline, as a statutory procedural requirement, as a procedure tailored to the subject, greater importance and emphasis on each of these earlier stages. While picture 1 on the right gives the 5, the same purpose is sought to be achieved by the picture 2 taken from the air conditioning filters, where at stage 1 it is pleadings and the rival claims and defenses are presented to the court. And some facts are admitted, some are disputed. If they are disputed, they emerge as a fact in issue. I'll stop here for a moment. The traditional approach was, all right, whatever pleadings have been filed, no need of worrying at this stage. Let us proceed, frame the issues and put it for plaintiff's evidence. This approach, even keeping commercial courts apart, was inefficient. It was only a traditional approach. It was not a mandate of the Civil Procedure Code, the earlier one, by itself. Friends, pleadings are the foundation of the case. They deserve the importance at our hands, at lawyers, and at the hands of judicial officers before whom we appear. The pleadings have to be properly put down. Unnecessary flab has to be removed, but removal of flab means that you retain what is material and details of that material, as I have explained in another picture 3, but I'll just speed up to come to that. A big problem is a written statement today. A plaint should be written in as many short paragraphs as they can be. To write long paragraphs, it should be as short as possible, because it is one thought, one fact, which can come in a group of 3, 4, or 5 paragraphs in a plaint, because they together are the separate facts that constitute that one material fact. Or in a plaint, it will be the material fact followed by 3 or 4 paragraphs containing the details and particulars. I loaned him money. Next. Sorry. Please, he asked me for a loan. Next. I loaned him money. Next. I did so by check number so and so, dated such and such. Next. This check was encashed on this date, debited to my account, credited to his. This remained outstanding. Now, this is further details and particulars of a routine, simple application that yes, I loaned him money. However, our CPC allowed us under Order 11, Rule 1 and Rules 12 and 14 to deliver interrogatories to the other, and also make a prayer for discovery and production of documents, Rules 12 and 14, with its attendant Form number 5, Appendix C to the Code. Friends, let me ask you, especially those who have been in practice for very many years. Of course, I will not be able to hear your answer here in Delhi, but I can presume. How often you have moved yourself application for leave to deliver interrogatories, or another application for discovery and production of documents, or faced similar application by the other side? Because you could be appearing for any one of the two. How often? Friends, this lies the inefficiency in the traditional approach. The procedure is there. We don't follow it. We don't make use of it. I'll put it this way. Because if what was a wide dispute, you can see my hands wide, if we follow these preparatory procedures, that reduces in width, narrows down, truncates, and that is the purpose of stage 2 and 3 of the civil judicial process, which our new Commercial Court Act is now trying to lay emphasis on. Stage 3 is issues. There is no practice of having a 3-column list of dates to be filed by both the parties before the matter is taken up for framing of issues. This is as far as the parties are concerned. There is no practice of the parties themselves telling the learned judge or the judge inquiring which are the admitted facts, let me note, so that they are no longer an issue. Or even if they were issue on the pleadings, by reason of answer to the interrogatories, documents that have since appeared, they cease to be an issue. Only this is an issue. And that narrow issue is framed after truncating removing all the unnecessaries. Now we come to the stage of evidence. Evidence today is very, very different than it was in the past. As I said, if I were as a lawyer appearing 100 years ago, I'm talking even long before I was born, on the same CPC, the evidence will be only oral. There will be no evidence I could file before the issues were framed. That inefficient tradition has continued. Friends, if today evidence is, say, 100 units at the trial, in a commercial dispute, 99%, or maybe 98, 99, it will depend, can be received in advance at the pleadings, at the documents and discovery interrogatories, and at the pre-trial stage. And the court or the arbitrator can say, well, file is complete, let us proceed to arguments, no need of oral evidence. Even in non-commercial matters, I will say 75% of the evidence can be received by way of these procedural tools which are provided by the CPC, even as the original CPC unamended by the Commercial Courts Act. So if we are able to follow the principles and ignore the traditional bind, the habit, look to it afresh, it is much greater efficiency we can achieve in civil litigation. Lastly, before I close this session, the next will be commercial. There are 4 aspects which I must lay emphasis on. I'll begin. What is purity in presentation? Picture 7, please. Purity in presentation. Now, this diagram seeks to show what is theoretical truth, what may be a little error or deviation of perception by a party, be it a plaintiff or a defendant. And this is fact of law, not law, fact. But in the pleadings, when they are presented, do we investigate in a pre-trial investigation? Do we self-filter? Do we check? Or we simply place it as it, whatever was our impression, without double checking? No. We have 2 kinds of parties in our courts. One party does, usually in the right, but does self-filter, self-checking, and tries to reduce the deviation from the notional 20 degrees to as close to the truth as he can. And there is the other party who says, yes, I will use my skills to actually create further deviation. I will sully it. I call it sullying, adding more impurity. One party does that. Now, why does he do that? Now, this is what has to be understood as the incentive or the motive. The problem with our courts, rather I would say our system, has been not adherence to the principles of one, restitution. Because there is always gain for the wrongdoer from delays. If the wrongdoer knows that whatever I am gaining by the delays, I will one day have to pay the one who is successful. A plaintiff in the wrong who troubles the defendant should know that not only will my suit be dismissed, whatever is the compensation for the injury that I have caused to the defendant by these 2, 4, 5, 6 years of delay, that will also I have to compensate the defendant. This is court's inherent jurisdiction, and now the Supreme Court has made it very clear that this can be granted and must be granted, restitution. And the judgments on this is in the Indian Council for Enviro Legal Action and also quoted in the later judgments of the Constitution Bench. There is also the earlier Ram Rameshwari and Maria Margrida. The first is restitution. The second is realistic costs. You know very well what it costs your party whom we are appearing for, whether paid to us or otherwise spent on the juniors, on the staff, on the travel to our office or his time at home. Unless that realistic cost is pressed by the lawyers and ordered by the courts to be paid by the unsuccessful party to the prevailing party, this incentive will not go. Lastly, there is the provision already there for prosecution for perjury, section 340 CRPC, that wherever the false statement is made in the pleadings, documents or evidence, that is offenses against administration of justice, the courts earlier were reluctant, but now are increasingly proceeding to order prosecution under section 340 CRPC. I've been noticing a change. Of course, it needs a more change, but I've been noticing where parties have virtually said, well, earlier I would have made a false statement, but today I feel scared and would hold back. So our task as lawyers is justice. It is not that we should falter on our part. We are officers of the court. We have to assist the court in doing justice. And as far as this perjury is concerned, there are two very nice judgments from the Delhi High Court. One is in Sanjeev Kumar Mittal versus State. And there is also the judgment in the National Highway Authority case later, which reiterated the view, and false pleadings are found punishable under section 209 of the IPC. But this has been a welcome move in the last few years. Earlier, courts were reluctant because the law required that the magistrate, the civil judge who ordered prosecution will have to appear as a witness. But that has been corrected in 2005. He need not appear. Yet, there is an impression. In fact, the message that he need not appear does not seem to have been as well entrenched as it should have been. And therefore, it falls to us as lawyers. We look to address to the judge that, look, you don't have to appear as in the past. These are the facts which make it a clear case of perjury, and therefore or offense against administration of justice, and therefore kindly order the inquiry. Section 340 is clear. The two judgments I referred will help you give the procedure, but you as lawyers have to move this application. But again, before moving, satisfy yourself that the case is one which calls for action and is just not take a chance. That may not be a correct approach. Friends, then if this approach for general civil litigation, I would have loved to address more, but then time constraints, I will only say if this approach is followed, civil litigation will become less costly, more and greater satisfaction providing to us as lawyers and respect to our legal system at the hands of parties, because which we find public confidence and trust is eroding. It is essential that we help restore, improve, and still improve, and that in turn causes economic activity, more efficient economic activity, both in quantity and in efficiency. And with economic activity, we get more employment, more production, with better wages, and the whole economy goes up, which is also our duty as citizens of this country. So with that, I'll say thank you to the Academy for giving me the opportunity for this first session, to the participants for attending, and I will take a 10-minute break when I come to the second session where I'll address only on the Commercial Courts Act. This was necessary as a foundation for what is going to be my address after 10 minutes. Thank you.
Thank you, sir. We will meet after 10 minutes. And my request to all the participants, please don't get disconnected. We will continue on the same link. So we'll meet after 10 minutes. Thank you.
They can see me.
So can you hear me?
Yes.
So we can see you, sir.
Right.
Are we good to go?
Yes.
So we all are here. So
Yes, sir. Please go ahead.
so you're live.
Yes.
Uh,
Good afternoon, friends. I continue with the second part of the session. The first part, I addressed certain fundamentals of the civil judicial process with a twofold purpose. One, to achieve greater efficiency in civil litigation. And two, now that is the real purpose here. Unless we are clear with those principles and approach as the basics, we cannot proceed with our Commercial Courts Act the way we can or should. Only to explain the importance and nothing more, I will take two hypothetical young lawyers attempting to straight away learn and practice the Commercial Courts Act. And in 6 months or 1 year of earlier practice, they have only idea of the traditional approach to the 1908 CPC. The lawyer one will have difficulty. But lawyer two takes an approach identically placed, takes an approach, well, let me spend a month or two training myself, self-training on the fundamentals of the civil judicial process and the 1908 code. These are the fundamentals I addressed in the first part. For 1 month, he does self-training, self-learning. And then he says, all right, now give me the Commercial Courts Act and I'll start. 6 months still later, in this hypothetical test case that I am making, lawyer 2 will be far more skilled, reputed, and sought after as compared to lawyer 1. And there is a reason. The reasons are two. One, in the self-learning process. One is the procedure, and second is reading the elements of the statute, which is what I addressed earlier. The various parts of substantive law that come to be four in the Commercial Courts Act, lawyer 1 will look at case law, which is not very much as yet. It will develop. Lawyer 2 will go on first principles and reading the text, breaking into elements of the substantive law. The result is the second gentleman will be, I'll simply say, successful and find his way up as compared to the first gentleman. This is the importance of the fundamentals for efficiency generally and fundamentals as a ground for the Commercial Courts Act. What exactly is the Commercial Courts Act? I will put it like this, one sentence, short. It is a tailored CPC for the purposes of adjudicating commercial disputes. And why it was framed? Again, I'm just putting it only to express the point. The traditional CPC was not yielding the kind of efficiency because of the adherence to tradition, I'll place it, and absence of certain provisions which is necessary for an efficient commercial dispute resolution. And that is why our legislature, to promote justice in the commercial field, enacted this Commercial Courts Act. I would say a fine piece of legislation, a required piece of legislation, and it's now up to us as lawyers to make the best of it. You know, the tools the government can give us, but ultimately how we use them lies in our hands. And that is what I appeal. A procedural tool, a guiding tool, which this act gives us to decide. Let us use it to make some fine paintings or products, justice in our case. The act has to be considered in its own perspective. I will say two parts are essential. And if these two parts you are able, as my friends, and I think I can say young friends, because I do not know, but I should be the senior most in age, at least, and of those who are participating today. Understand what exactly falls within the definition of a commercial dispute and is therefore taken away from the regular civil court to the commercial court. One major goal. And the second major goal is the amendments. I call it tailoring. Common parlance is amendments to the 1908 CPC in its application to the commercial court. Much of those amendments are, except one or two, are not something new which were not there. They were always there, but some silently, some impliedly, some clearly, some not so clearly. But one thing was certain, they were not used. Nobody gave attention to the pleadings. All right. So people did not carry out pre-filing investigation. Very well. So what the framers in their wisdom, and rightly so, did was provide for a special affidavit in the schedule that the pleadings will have to be supported by an affidavit. After the session, I will request the participants to go through twice over that form for the affidavit and then think, does it not ensure greater purity in presentation and open the party in the wrong who sullied, added impurity, as I said in picture 7 earlier, to sanctions or prosecution for perjury. Let me place it again hypothetically. If I were to pick up 50 pleadings with the old pattern and 50 pleadings which are supported by the affidavit as prescribed in the schedule by the Commercial Courts Act, the first 50 will contain, I'm putting a notional figure for discussion, 80% impurity. That is your experience. Of course, there are two parties in the adversarial system, and when I say 80%, I would obviously I'm referring to the party who's in the wrong. But when it comes to the affidavit that is now prescribed, provided the courts, and this is my appeal to the courts, that courts also take it with the seriousness that it deserves, and you make a submission to that effect that yes, this is falsehood, this is concealment, here is the affidavit, please 340 proceed under. That 80% will fall down to 30% almost straight away, and once the message goes across that yes, the courts are willing to take action against this false affidavit, it will fall down from 30, further reduced to 25, 20, maybe 10. It will take its time. It won't happen overnight because habits take time to change and the message also takes time to go out. But a little introspection at your end where I'll say we as a lawyer, we tell our clients, look, this is the affidavit. Make sure you have carried out pre-filing investigation. Make sure that nothing is wrong. No false statements, no misstatements, no concealments, all documents, etc. The pleadings have to be proper. At this stage, before I go to the further stages, I want to refer to a very good feature, and that is virtually, we can call it coaxing or forcing the parties to go in for mediation, even pre-litigation mediation. Why is it necessary? What does mediation help? Now there are two parts. Again, I'm putting it theoretically. In one dispute, both the parties are at least dil ka saaf. They have no evil intention. Yet there is a dispute. But this dispute is something which is an error of perception. That 20-degree deviation I showed in picture 7. If the mediator helps them, look, this is how you correct your perception. Examine this, go search for this, try this. And this is the law. Read for yourself. Understand what are your rights on those facts and documents. The result is both the parties who are having a dispute, they say, okay, this part I think we were wrong in claiming, or this part we were wrong in denying. The dispute narrows down. But this is a case where the parties are both well-intentioned. The other mediation, where one of the two parties is not well-intentioned. He simply says, all right, 50-50 कर लेते हैं. भाई 50-50 वो करो अगर सच्चा है या genuine dispute है. You can't file a false claim against somebody for recovery of 100 and say, okay, I'll keep on troubling you in court. And because there is no restitution, no cost, no prosecution, you cough up 50 as settlement. Otherwise, I'll continue troubling you. Conversely, if 100 is actually due, why should you not pay 100? I can understand asking for installment or some time to pay. But that full 100 has to be paid. Mediation is not that I owe you 100, but because I'm in mediation, I will settle for 50. I just gave these two extreme examples to put across the point. But friends, let me tell you, mediation properly conducted and with the right thought in mind is a very, very useful device, a process, and only this part you will not find in much literature, because we have sometimes a tendency to copy literature from the West without actually applying our own mind how it will operate in our conditions. The success of the mediation depends on what is the umbrella under which it operates. That is, what the civil justice system will ultimately do as giving relief, denying relief, or ordering prosecution of the one who was wrong in the mediation. Mediation papers do not go before the court, but that process in the wrongdoer's mind, that yes, I'll succeed with my wrong, that confidence in his skills to succeed with a wrong is what has to be taken out. And that is when the civil court justice delivery, with, as I addressed in the earlier part, with its restitution, realistic costs, timely disposal, attention to pleadings, then the mediation has much more to offer. It is hoped that today when I lecture in 2020, mediation has 1 point success or a particular degree of success. But when the academy gives me opportunity 1 year later to address you, by then the mediation has a greater degree of success which is witnessed in the mediation cells in your state or anywhere in the country, as a matter of fact. Now I'm coming back. Pleadings, interrogatories, documents, admission denial, discovery and production. The CPC is amended and it gives additional power to the court to decree a suit or dismiss a suit at the issue stage itself. Summary. Okay, this has to be understood. Now there are two practical things I want to speak out at this juncture. One is, may I request Chetanji to put up that section 2 on the screen.
So,
the Commercial Courts Act has section 2. Now this is the most important section because it defines what is a commercial dispute in clause 1C. Section 2 1C. Can you take it up, please? Now what I am presenting to you is only what is the statute. But here I have print formatted in a particular manner for your convenience. Because if you notice the print material which is lying on your desk while you are here, viewing this lecture of mine, the print would be different. And this formatting of the same very words will be of convenience to my colleagues. Now kindly see, C has a clause 1. Ordinary transactions of merchants, bankers, financiers, traders, such as those relating to mercantile documents, including enforcement and interpretation of such documents. Now this is a reasonably flexible term. So is the next. Case law on this will develop. And how it will develop? It is not a bright line statute. You as lawyers will make a submission to the court in a commercial matter and a submission based on first principles and statutory analysis, which I referred to earlier part of the session. Based on your submission, the court will decide. Those decisions will be case law. Now even the first instance judgments are all available on the net, unlike in the past, where only high courts were available. Then, if any of that matter is tested further in the high court, that whether your interpretation of, we call it interpretational common law of each of these clauses, it will have. But then you will have to prepare it on first principles and with reference to number of other relating statutes. I'm using the word relating statutes. For instance, we take clause 2, export or import. Now there are several statutes which determine, some are revenue statutes or foreign exchange statutes, which determine what is an export or import. So it is not simply a general understanding. It is an overall reading understanding of what would really be a dispute which falls in a particular subclause of clause C. Now kindly proceed further. Chetanji, now you see 9, 10, 11, now we have 12. Now 12, shareholders agreements. Now 12 is, you will have to have Contract Act, you will have to have the Companies Act, and there will be some restrictions on under the various rules. So all these peripheral statutes will have to be considered by you in relation to A, whether it is a commercial dispute, and B, if it is a commercial dispute, how it is going to be more properly and more efficiently adjudicated upon by the courts. Now kindly have further down, please, intellectual property. Now we have that those laws, they will have to be kept. Now semiconductor integrated circuits, another field. Again, there is technical, there is commercial, and there are so many other fields. But it is what I am pointing out is, in some of the other statutes, it was just reading a clause and that's the end of this matter. Here, these clauses only provide you as a focal point, and you have to consider it as the various satellites which will help. Now kindly see the next one, agreements for sale of goods or provision of services. Now Sale of Goods Act, we have the old one that will continue to apply when it comes to clause 18. But provision of services, what exactly is a service? What kind of service would be covered? These are all issues or questions we will have to keep our eyes open, consider, and then let us put it in services. We might take the help of what is a service within the meaning of goods and services or the tax, GST, or the income tax, and so on. Proceed further, please. Chetanji, and further. Now, what I want, now come, yes, 19 is there, 20 is insurance, and 21 of agency, 22 the government has kept, and rightly so, the residuary power to notify other commercial disputes has come to the fore. Now, after that is a small note. This note is not there in the statute. It is only to be of convenience to my friends that I have added it in this print. That there are two explanations. And the explanation which appears below this is an explanation which only covers clause C and not the other parts of this section. And the difficulty arises is, you will see it later in your own printed act, the explanation is A clause and clause B. And after clause B, it comes clause D. Now this clause D is not in series with B. It is totally independent and goes up to what was C as the fourth clause, because there is a double A on the first page. Otherwise, right when it came, one of the young lawyers commented, "Wai B के बाद C कहाँ चला गया? सीधा D आ गया? ये misprint है या क्या है?" No, that is for your convenience. The D is totally different than the B, and the A and B are only explanation to the various clauses up to 22, which I have described above, including ones that may be notified. The rest are not relevant today. What is now the next part of reference is section. Kindly have the section which amends the CPC. Have my friends got their own statute in their hands? Now kindly come to chapter 6, section 16. I don't have it on the screen. Chetanji, if I can just show it for my... Just no, pictures are all over now. Just see if this can go.
So just a second, try. Yes, sir, we can see it now. Section 16?
Yes.
Yes, sir, we can see it.
So this section 16 amends this old CPC in your office when it comes to application to the commercial court. A small tip to my friends in Maharashtra. Please buy yourself another copy of the CPC. And on the opening page at the cover, with a red marker pen, write for commercial court. And the old copy is for the traditional court, so that you don't mix up between the two. Though the new prints have both, yet it will be more convenient that you mark a copy for commercial court. And then what you do is the next. Now kindly see section 18 of the Act, 16 of the Act. Section 16 is a long section because it actually extends to the schedule. And section itself is only subsection 1, 2 and 3. And subsection 1 of 16 refers to the schedule. Now, if you go to the schedule, may I request my friends, of course I can't see, that open up the schedule, which in your book, statute, you will see it begins amendment of section 26 CPC, substitution of new section 35, that is given. Then it goes new 35A amendment, then amendment of the first schedule. Now this is the first schedule to the 1908 code. It's not the schedule of this act, but somehow the other tradition, we never refer to a schedule, we simply say order 1 rule 10 party, order 6 rule 17 amendment. So those orders are part of the first schedule of the 1908 code. Here you will see that so many orders and rules have been amended. Some have been inserted by this schedule. For instance, if you go, summary judgment has been inserted as an order 13A in the CPC. So if it's a commercial dispute as defined in section 2, the court has power of summary judgment. If it is not, then it has no power because the original CPC is continuing as it is. So it is the understanding and reading these amendments dehorse the original. And with the fundamentals what I addressed in the first part of the session, that will allow us to achieve the maximum utility out of this new legislation. Again, on the practical side, pick up your extra copy of your old CPC, mark it on the top for commercial court work, and then one day, or hopefully this weekend, not later, pick up yourself a highlighter and a red pen, a red marker pen. And whichever are the orders which are inserted, they will be there in any copy of CPC published after 2018. Mark the beginning of that with a red, and what is till the point it continues, you mark it with a yellow marker in your copy. And keep this as a separate commercial code CPC and the other one as a regular code CPC. This will, my friends, it will enable you to use better, to have a greater insight. And again, as I said, based on first principles, you interpret, ultimate goal is justice. Try and put it before the court, request the court for appropriate orders, and then you will see that commercial justice succeeds. We need much greater, much quicker, lower cost justice delivery in the commercial field for our Atmanirbhar Bharat. It is essential. At this stage, before closing, I want to point out to one psychological and economic formula. They are two interrelated. If a person knows that yes, if I get commercial justice from the courts, he is willing to venture more, invest more, create more economic activity. That benefits the nation. But if he does not, I would say, achieve that confidence in the justice delivery system, and with due respect, there has been erosion of confidence in the past because of delays. But if once that confidence is restored and greater confidence is achieved, that yes, if I'm entitled to 100, I will have my 100 plus restitution costs realistic. And if I'm not entitled, I will not have it. Or if somebody sues me and I owe him money or in a commercial dispute, soon the court will decide against me. I will not be able to tire him out in the past as I used to do in the past. Now what happens is, this sends out a message in common terms, common parlance, and a positive externality in the economics parlance. Now, if this message goes out, those who were intending to create a dispute, they don't create it. To use colloquial language, A, there is greater economic activity. B, where disputes used to arise just to make profit or just to have convenience, they say, अब dispute करने का कोई फायदा नहीं है, फालतू का dispute. Genuine हो तो चलो, फालतू dispute का कोई फायदा नहीं. Once with your effort and the effort of all stakeholders, such is the commercial justice delivery in your state, you will see what will be the economic growth. And it is that economic growth alone which will give us our basic, some of us, but they also deserve their basic social goods and services and opportunities. That will come. There will be infrastructure development. There will be so much other availability and general benefit to the masses, all because of more efficient, timely commercial justice. And once again, because of efficient, timely and effective commercial justice, the accrual of the dispute, which was, as I said, my own research experience as a lawyer and also research, 80% of the disputes were non-genuine. Now that 80, if it falls down to 5, it's easy for the court to decide. And they won't arise. Because again, this is important. I'm repeating with your pardon. Unless the parties get the message कि गलत dispute करना, गलत claim करना, गलत defense करना में कोई नहीं रखा, वो जमाना चला गया. That is where our joint effort will bring not only success to this legislation, but economic growth and social welfare, which is what we are looking for. Justice in the true sense. So with that, I will close my address and I will ask the Joint Director Sahab if he wants me to address on any further point. Yes, please.
Sir, we have a query.
Yes.
This is relating to state matter. If the state government participated in pre-trial mediation process, then is it necessary to issue notice under section 80 CPC prior to registration of suit? So indirectly, sir, section 80 notice will be first or notice will be first likewise.
You see, I will put it like this.
Sure.
Section 80, long framed, never served any purpose, but it is there. And unless that statutory exception is made, on first principles, my impression is that notice would be necessary, though because in mediation papers, if they are filed, because they can't be called to court. Otherwise, I could have argued that filing of the mediation paper is giving the substance, and therefore 80 stands satisfied. But I would have on the existing some reservations to say that it is not necessary.
Sir, in Teams, because many advocates are watching through YouTube mainly, Teams is not comfortable to them, therefore they are not connected through the Teams. And in YouTube, sir, there are near about they reach around 40, but almost all of them are Thanksgiving and remarks that it is very informative session, and queries as such are not remaining, sir.
Thank you. I will only make one appeal to the lawyers.
Sure.
If whatever I have labored today to speak enables you to give greater justice and commercial activity and economic growth to the state of Maharashtra, I will be the happy man. Then I will again come to Maharashtra to see the growth. With that, I'll say thank you and Jai Hind.
Now, sir, allow me to express vote of thanks. Sir, today you have in a very short time touched the very important aspects which are crucial for not only for the commercial disputes but also for any other civil dispute, or for that sake any dispute before the court. You have highlighted the practices which are in fact not much used, but they should be used for a right approach to the civil litigation. And your delivery of the top session today is in a very organized manner, sir, very brief and touching the important aspects. And I am sure that your deliberations and the lecture today will take the advocates to again to use those provisions and excel to bring the administration of justice to a good speed and required inexpensive, especially because it curtails not only the time, I see it as inexpensive. On behalf of the Maharashtra Judicial Academy and all the participants, my brothers and sisters, I express my great gratitude, sir, and with again humble request to come again for another webinar or session, and I express my thanks. I express my special thanks to the SCC Online, my co-host Chetan Singh, and the SCC Online management, Mr. Kapoor and Mr. Karan, all the SCC Online and the team also who are supporting, providing the backend support. I express my gratitude to the Bar Council, the bar associations, and all my friends, judges who have spread the message of this webinar today to disseminate the knowledge. Thank you very much, sir.
So this webinar will also be available on YouTube with the same link. So the link, members who are watching this on YouTube, you can save this link and this will be there on the YouTube forever. So that's what I want to wrap. So sir, with everyone's permission, we'll end this webinar now.
Yes, thank you.
Thank you, Armon sir. Thank you, Alaga sir. And we end this now.